Okay, good morning everybody, and thank you for joining Rix and Kay's Employment Law Update webinar. My name is Scott Garner. I'm just going to do a quick introduction and give you some of the checks that we're going to do before we start, just so that you know. The webinar will be recorded and it will be published on our website post-event. All of the attendees do remain anonymous, so you don't have to worry about that. From a Q&A point of view, we will address questions at the end of the webinar. You can submit your questions using the Q&A function at the bottom of your screen. Depending on how many questions there are, we will try and address them all at the end. If there are an abundance of questions, we will come back to you after the event's finished with a response one way or another, so we hope that's okay. Just before I hand over to Amy, who's going to begin, I'm sure most of you are familiar with Rix and Kay, but for those who may be new to the firm, just a quick update from our perspective. We are a full-service law firm with offices based across Sussex and Kent. So we're here to support our clients in the region, and we do have a dedicated COVID-19 support and advice blog with a whole range of advice for businesses and individuals. So please do go and take a look at that. Okay, I'm now going to hand over to Amy, who's going to begin the first part of the webinar.
Thank you, Scott. As Scott said, I'm Amy White, Associate Solicitor with Rix and Kay, based in the employment team. And I'm going to begin today's seminar by looking at the Coronavirus Job Retention Scheme, which I know is something that lots of people are interested in at the moment. And then thereafter, Victoria Regan, partner in my team, is going to take over and focus on planning return to work and wellbeing for the second part of the seminar. So, COVID-19 is the focus of today's seminar, of course, and it has presented an unprecedented situation for employers. I know that's something that's been said a lot, but it's certainly not untrue at the moment. It's presented numerous challenges. At the outset, we had questions around home working and how we could do that practically and legally. And then as things moved on, we had questions around changes to the SSP regime, questions around self-isolation and shielding and how that would interact with work. And the guidance and advice, I'm sure you'll agree, just appeared to be changing on an almost daily basis. As an employment lawyer, it was really exciting, perhaps, to be receiving updates on the law at 5:30 on a Friday afternoon. But moving to the next slide, the biggest development that we've seen really in relation to COVID from an employment perspective has been the introduction on the 20th of March of the government's Coronavirus Job Retention Scheme. The scheme was intended, or is intended, to help employers whose operations have been severely affected by coronavirus to retain their employees and in turn to protect the UK economy. And you can see from the statistics that I've put on the slide there that it's done a good job in that regard. It's been very well used, 7.5 million workers supported and almost 1 million businesses. Moving to the next slide, we know that the duration of the scheme was always intended to be temporary. Initially, it was due to run between the 1st of March and the 31st of May, so a 3-month period and a backdated start date. But since then, we've had 2 updates as to its duration. And we now know that it has been extended to run until the end of October, but that changes will come into effect, and I'll touch on that some more later. What the scheme does is it introduces the concept of furlough leave. Essentially, employers who can't maintain their current workforce because of COVID disruption can furlough their staff, i.e. send them home without work for a temporary period, and they will receive a reduced rate of pay, namely 80% of their monthly wage costs up to a £2,500 per month cap. I think it's worth saying that furlough is an entirely new term, an entirely new concept in UK employment law, so we are all coming at this together afresh. Furlough leave is available to employers at any point during the currency of the Coronavirus Job Retention Scheme. You can make use of it at any time. The key issue, of course, is there no work or is there reduced work for your employees to do such that you need to make use of the scheme? And if you're going as an employer to furlough an employee, you must do so for a minimum of 3 consecutive weeks. There is, however, the option to rotate, and we didn't think that was going to be something that was permitted, but we now know it is. So you can furlough someone, then bring them back to work for a period, and then place them back on furlough leave again. We thought perhaps to control infection rates that wouldn't be allowed, but it's entirely legal. Employees cannot work whilst furloughed for their primary employer. or for a linked or associated employers. But there are things that they can do, and we'll touch on them. When we talk about work, that means not performing services and not generating revenue. And we certainly know that you can't be furloughed and work part-time for your employer at the same time. That would, of course, go against the entire purpose of the scheme. So in terms of things that employees can do whilst furloughed, they can undertake training. That is, of course, subject to them receiving at least the national minimum wage for any hours spent training. And with employees at the lower end of the earning spectrum, that might require the employer to top up those hours spent training. An employee can undertake work for another employer, not a linked employer, an entirely separate employer, subject to their contract, subject to that being permitted. Again, this is something that we thought might be prohibited under the scheme, but actually it would appear that the need for employees in certain industries, the NHS, care, fruit picking, etc., has trumped the need to stop employees working entirely whilst furloughed. And employees can also volunteer, but again, of course, not for their employer or an associated employer, which is a question I have been asked. Employees can be furloughed from more than one job. So if you have two jobs as an employee, you could be furloughed from both or just one, because each job is treated separately. The £2.5 grand cap in that regard also applies separately. So if you've got two jobs and you're a high earner in both and you're furloughed from both, then you may find that the income isn't too terrible. Moving to the next slide, we'll look at eligibility under the scheme. So from an employer's perspective, you need to have created and started a PAYE payroll on or before the 19th of March, have enrolled for PAYE online, and have a UK bank account. Worth saying that the reference date in that regard was previously the 28th of February, but that was shifted back to the 19th of March. And what this eligibility criteria does is it opens a wide range of employers up to eligibility under the scheme. So businesses, charities, public authorities in certain instances. We know, however, that public sector employers will generally be excluded from the scheme, and similarly that non-public sector employers who receive public funding for staff costs, again, shouldn't be utilising the scheme. It wouldn't be right if that funding for staff costs is continuing and then you furlough staff and also receive furlough pay. It's quite easy to understand. From the employee perspective, as regards eligibility, an employee must have been on the payroll on or before the 19th of March. And we know that the crucial element there is the RTI submission to HMRC. And again, that opens up a wide range of workers. So any kind of contract really is eligible, full or part-time, indefinite or fixed term, or even 0 hours. And what the scheme actually does is it widens the definition of employee. So as employment lawyers, we're always very conscious of differentiating between employees on the one hand and casual workers on the other as two separate types of status. But under the scheme, that differentiation is done away with, and office holders, LLP members, agency workers, and those casual workers are all treated as employees for the purposes of eligibility. And in that regard, we know that directors can be eligible under the scheme if they are salaried. So a company would have to adopt the decision to furlough a director as a formal decision of the board and recorded in the company records. Obviously, the furlough pay they receive will be based on their salary and not any other payments the director might receive by virtue of other statuses, for example, dividends as a shareholder. And once furloughed, a director needs to be very careful about what they do. They cannot work, and we know that means performing duties or performing work, generating revenue, etc. So all they can really do is perform the statutory duties that they are required to, and that might just be filing company accounts or attending an AGM, for example. And similarly, apprentices, we know, can be furloughed, and their apprenticeships can continue whilst furloughed. The training, again, can be undertaken during furlough leave, but must be paid at their national minimum wage rate. With apprentices, it's very likely then that if you are requiring them to undertake training, you might need to top up to reach that national minimum wage rate. And the guidance around apprenticeships is really keen to encourage the continuation of them, to encourage remote training, extensions to assessment timetables, and breaks in learning. One thing we know that must continue to be paid is the apprenticeship levy. The Treasury has confirmed that it's not going to pause payments in that regard. And moving to the next slide, this is an area where we had a lot of debate at the beginning and a lot of questions being raised. We knew that you could rehire someone who had been made redundant as a result of COVID disruption, but we didn't know what the position was in regards to those who had left voluntarily, i.e. resigned. But we did get some clarity later down the line, and we know again that you can rehire and furlough those sorts of employees if they ask for you to do so. Obviously, the eligibility criteria applies as stated on the slide. This is really useful for employees because we know that a lot of employees who had resigned were intending to start new roles, have found that the job offer has been withdrawn or their commencement date has been deferred, leaving them really between a rock and a hard place. That said, it's not compulsory for an employer to rehire and furlough in these sorts of circumstances, and we do think that caution should be exercised in that regard. It's not the primary intention of the scheme, so there's always a possibility that challenge or question could be raised later on. And an employer will, of course, be liable for that employee and their wages. Whilst the furlough scheme is there to cover the 80%, the employee will continue accruing holiday, for example, and we'll touch on how that needs to be paid later. And additionally, an employee who is rehired will be continuing with their continuous service, and they may gain, for example, the magic 2 years that entitles them to greater rights in relation to redundancy, unfair dismissal, etc. So just worth exercising caution there. The next slide deals with sickness absence. And again, this has changed over the duration of the scheme. So originally we knew that, or we believed that sick and self-isolating staff were entitled to SSP and that was it. We now know that actually if somebody is on long-term sick leave, if there is a business reason to do so, an employer may furlough them. This is of course not applicable to short-term absences through sick leave, particularly given that you must be furloughed for a minimum of 3 consecutive weeks to be eligible. We also know that you can furlough those who are shielding, those who live with someone who is shielding, those who've had caring responsibilities arising because of COVID, if they can't work from home. And we know that if somebody is on furlough leave and becomes ill, they can stay on furlough leave. They don't have to be transferred to sick leave and sick pay, which is obviously useful. They don't experience that reduction in pay. The biggest area of debate at the outset was the question of holiday and how it should be treated. And whilst HMRC have been very good in relation to the scheme, they were quite reluctant to provide guidance on this topic to begin with. And the guidance that they have provided is quite heavily caveated. But that said, we know that holiday can be taken during furlough leave as things stand, and that an employer can direct an employee to take holiday during furlough leave, so long as they do so on minimum notice, so providing double the notice as the leave to be taken. And we also know that holiday must be paid at full rate. The working time regulations deal with the pay somebody is entitled to whilst on holiday, and they say a normal week's pay, and that doesn't change under the scheme. If you are going to require your staff to take holiday whilst furloughed, to stay on top of accrual, for example, then you must chop it up to ensure the employees are receiving their normal rate of pay for that holiday. In terms of putting someone on furlough leave, it's a designation, and that requires a written agreement confirming particularly that the employee will cease all work for the employer. The written record can take a variety of forms. It might be a letter, it might be an agreement, it might be an email, but it must be retained because HMRC has said explicitly that it will audit claims, so you do want to make sure that you're keeping clear records. As to how you select who you're going to furlough, little guidance has been provided, so we would recommend at least a rough and ready selection matrix that focuses on business need, thinking about where there is that reduction, where that's been this disruption to workloads, and then identifying those who to furlough from that. That's really important, both in terms of having records, but also as to avoiding discriminatory decisions. Looking at wages then, as I said at the outset, under the scheme, an employer can claim for 80% of an employee's wages, up to a maximum of £2,500 from the date they finish work. So rather than the date that the decision is made to furlough them or the date that the employee is written to concerning furlough leave. And that's important when we think about those staff who are backdated. Perhaps they were laid off before the scheme came into being. An employer can choose to top up the 80% if they want to do so, but there is no obligation in that regard. And an employer can also claim an additional sum in respect of NI and auto-enrolment pension contributions. But of course, the claim in that regard will be based on furlough salary and not normal salary. When you're thinking about calculating earnings, there are really two ways of doing it. In terms of salaried employees, it's the basic calculation, 80% of the gross salary as at the 19th of March. Where somebody has variable earnings, there are two options and you select the highest. So either the employee's earnings from the same month in the previous year, or their average monthly earnings for the 1920 tax year, or the duration of their employment if shorter. And the sum that the employee then receives based on that calculation will be subject to normal deductions, tax, pension, unless they've opted out, student loan, etc. Regarding wage costs, this is another area where there's been a lot of debate, lots of change, and there's still it's still a little murky. Originally, we were told you couldn't claim for fees, for commission, for bonuses. Then the later guidance said, well, what you can claim for is regular payments. So that might include wages, but also past overtime, fees, compulsory commission. The position we seem to be in now is that if something is non-discretionary, if an employee has a contractual enforceable right and an employer is contractually obliged to pay the sum, then it may be treated as wage costs. But we know explicitly that we cannot claim for pension contributions in excess of the mandatory level, for discretionary bonuses, discretionary commission, non-cash payments such as benefits in kind or benefits provided through salary sacrifice. Moving on then to the way in which we apply. We do so through the HMRC online portal, which I'm sure many of you have utilised. You'll know that there was a great deal of worry at the outset about how well this was going to withstand the amount of claims that were likely to be made, but it's done a really good job. Most of the things I hear are very positive. And I'm hearing on the whole that payments are being made within that 4 to 6 day time frame. We know, of course, that an employer cannot charge its employees fees for using the scheme. It must pay the entire grant received to the employees. And finally, just moving to my final slide, thinking about future developments, because I know that as we move through the scheme, people are thinking about the future. We've recently obviously been told that the scheme will be extended to the end of October, and it won't change in its structure or its form prior to the end of July. But from then onwards, there will be changes, and we believe that that will involve furloughed workers being able to return to work part-time, continuing to receive 80% of their wage costs as a minimum, but the employer then being asked to contribute towards that sum in some fashion, perhaps a 60-20 split is being spoken about. But we're expecting to get full details in that regard by the end of May. And obviously we will update clients as that update comes in. As the scheme changes, of course, I'm sure lots of employers out there are thinking more long term and are having to think about staffing levels, wage costs, etc., in a more long term fashion, and that might include thinking about things like redundancy. What I would say is it's important to take legal advice. The interaction between furlough and redundancy is pretty tricky, and actually it's one instance where to say that every case has to be taken on its individual facts is absolutely true. So if you are having to think about those long-term decisions now, do get in touch because it's worth really thinking about them very carefully before you get going with any procedure like that. So that is a whistle-stop tour of the Coronavirus Job Retention Scheme. As Scott said, we'll take questions later, but I will now hand over to Victoria Regan, partner in the employment team, who's going to move on to planning return to work and wellbeing. Thank you very much.
Thank you, Amy. So my name's Victoria Regan, and I am a partner in the employment team at Regan and Amy Listers. So for this part of the webinar, I will be looking at return to work and wellbeing. Let's return to the first slide. So following the Prime Minister's announcement on 10th of May, Government published a set of guidance to assist employers in ensuring that their workers can return to work safely. These are the COVID-19 secure guidelines. But from the outset, I really must just stress that the message has not changed. The position is the same. If an employee can work from home, they must continue to do so. But if an employee cannot, then they should be encouraged to go to work, but to discuss this with their employer. So moving to the next slide, we'll see that employers have to follow a vast and complex body of health and safety legislation wrapped up in common law, health and safety acts and associated regulations. But in short, they have to ensure the health and safety of individuals in the workplace. They have to provide a safe place and a safe system of work and implement those plans and systems. Failing to do so could result in directors being personally liable. One of the main obligations is that they must undertake a risk assessment in consultation with employees and union representatives, and really just to identify any health and safety risks to their workforce and to take steps to mitigate the risks. So moving on, it's for this reason I believe that all businesses, when planning return to work, will need to undertake a COVID-19 risk assessment. So when looking at the workplace, I just highlighted a few areas for consideration. Cleaning, really reinforcing the necessity for cleaning and perhaps increasing the necessity, and focusing on touch points such as door handles or keyboards. Looking at hygiene and washing facilities, so obviously the provision of antibacterial wipes or hand gel around the workplace, and also in particular around shared equipment. Consider limiting access or closing off of small spaces. In particular, what I'm thinking here is where the social distancing cannot be maintained, and in particular, perhaps in a lift, and it might just be an outright decision that all individuals are to use the stairs. Perhaps consider having a one-way system and then putting floor markings down throughout the building. And real consideration will need to be taken to look at seating layouts and workstations to really see if social distancing can be maintained. And if not, to then further consider if additional barriers or screens will be necessary to provide protection. Also looking at the limiting use of facilities in communal areas such as kitchens, gyms, canteens. And also further thought will need to be given as to how to deal with visitors to the workplace and perhaps have further protocols on this. So then when looking at your employees, your workforce, obviously the key element here is looking at whether social distancing can be maintained wherever possible. And then if not, then perhaps considering mitigating factors to reduce transmission. But then if not, to then genuinely assess if a particular activity can be undertaken safely at all. Perhaps consider staggering start times, shift patterns, and having teams and cohorts to try and limit the number of people in the workplace at any one time. And wherever possible, holding meetings by video conferencing or perhaps a good old-fashioned telephone. But if not, then have further provision as to how those meetings will be conducted, thinking about spacing, timing, ventilation. Also consider to limit the number of times that employees may be able to enter and exit the building. But further thought will need to be given as to your vulnerable people in the workplace and what protections you need to put in place for them. I put travel here, and whilst ordinarily how an employee gets to and from work would not ordinarily be the employer's obligation to consider. But I say it's absolutely vital as part of any COVID-19 risk assessment, because obviously if an employee is travelling by way of public transport, there's a potential risk to them, but also to the rest of the workforce. In respect of PPE, government guidance is that it is not necessary to provide anything over and above that what is already provided. But if you do decide to provide additional PPE, then further consideration may need to be given as to training. So turning to the next slide. In addition to protecting the physical health of employees, it's also important to think about the impact that this lockdown, that this pandemic has had upon an individual's mental health. Employees may be concerned or anxious about returning to the workplace, many of whom may be struggling with challenging domestic situations, such as juggling with childcare, caring for a vulnerable relative, financial pressures, or perhaps having dealt with illness or bereavement, and without having the usual support systems around them. Some might be also concerned about travelling by way of public transport, and also wondering if social distancing will actually be maintained. So what is important here is to have a conversation, have open discussions, line managers, and also to have them trained to be able to speak to employees about their concerns. This can be obtained by having an initial questionnaire, but really by having a return to work meeting with individuals to have some form of reinduction, reorientation, and also to consider if there are any reasonable adjustments that you may need to put in place. It's important to be sympathetic to the concerns, but also to be mindful that different people may require different periods of time to adjust to the new normal. It's a good opportunity to remind the workforce of any access to employment assistance programs or occupational health, and also to inform them if there are any mental health first aiders or champions in the building. Next slide, please. Employers should also now take stock and review current policies, such as disciplinary, health and safety, mental health, flexible working, home working. But what we're finding is many employers are actually introducing a new policy, a new safe working policy, specifically dealing with the return to work, and also introducing new protocols to remind employees of their duties to look after their own health and safety and that of their colleagues. It would also be a good idea to have some form of mechanism through which employees can raise their concerns. And also, don't forget signposting. Together with the guidance, government did produce a poster to show to workers and visitors that you follow guidance. So that can be placed in entrances and exits, but also other signposting for mental health and for additional cleaning could be put up in key areas. One of the biggest hurdles that employers will face in this process is convincing employees that it is safe to return. It's for this reason that it is essential that employers, managers consult with their workforce in advance of their return so they can discuss the concerns and really establish the reason why they are concerned. Is it because of a particular vulnerability? For themselves, for their family, for childcare? But is it for something a bit more serious? Do they really genuinely believe that to return to the workforce would result in a serious and imminent danger? In this situation, it might be that has the employer failed to put in place adequate health and safety measures or shown complete disregard to any guidance? Is the working environment unsafe? And if so, any form of detriment, reduction, dismissal will more than likely result in an automatic unfair dismissal claim. So just moving to the next slide, I thought it would be helpful just to touch on a few potentially tricky areas where businesses may be met with refusals to return to work. So the high risk groups, we've obviously got those who are shielding. So these are the clinically extremely vulnerable, and the message is clear: they should stay at home. Perhaps another conversation about whether they can work from home or even in an alternative role, or perhaps they can remain on furlough, or if not, then they will be eligible for SSP. Just a word of caution here is that if they are shielding, they may be disabled under the Equality Act, and again, just be careful of any potential claims for discrimination or indeed whistleblowing. Another category here are those who actually live with extremely vulnerable relatives that they're supporting. Again, can they work from home? If not, can you ensure that the measures are in place to protect them, such as social distancing? And if not, then again, perhaps considering if furlough would be appropriate, because these are circumstances arising from the coronavirus. And the final group, the clinically vulnerable group, so those who are pregnant, over 70, underlying health conditions. Again, conversation, can they work from home? government guidance says really you should make every effort to allow this category to work from home. Can they be offered the safest available role on site, whereby 2 meters can be maintained? Is it necessary to undertake a further risk assessment to consider if it is an acceptable level of risk? If not, and if you cannot minimise this risk, perhaps again, furlough might be an option. And of course, if they're pregnant, then they can be suspended on full pay if there is no safe role for them. So as we touched on, there may be concerns about travelling on public transport to get to work. So whilst government's advised to try to not use public transport, it's obviously not been outlawed. This would probably need to be judged on a case-by-case basis in respect of the particular risk to that employee. Obviously, see if they can work from home, see if there are any alternatives to avoid travelling by way of public transport, or expanding bicycle storage facilities or car parking. And then if not, then perhaps consider changing their start times so that they can avoid particularly busy times and rush hours and minimise risk of contact. So those with childcare responsibilities, government's been a bit vague on this, albeit they have asked for employers to be reasonable in any requests here. The reality is, if they cannot return, there's little point in insisting that they do. So consider, can they remain on furlough? Or have a discussion with them about any options, such as working from home, or perhaps changing their working hours to fit around their other commitments. And then other options such as parental leave, unpaid leave, or annual leave. Again, just word of caution, before taking any kind of disciplinary action for refusals, this may well result in some form of indirect discrimination claims, or indeed breach of the implied duty of trust and confidence, resulting in constructive dismissal claims. And then lastly, if an employer believes that they have done absolutely everything within their power to mitigate risks and to follow health and safety guidance and guidelines, yet there is an employee that still refuses to return to work for no apparent reason, then unfortunately, it may well be a question or a discussion about unpaid leave, or ultimately disciplinary action for failing to adhere to management instruction. This will obviously be dependent upon the specific set of circumstances. What I will say is the answers are uncertain at present. We are in, as everyone's saying, in unprecedented times, but equally we don't have case law to refer to. And it may well be another 2 years before any claims actually get to the tribunal, so we will know the answers. I think the key here is just to talk to the employee about the concerns, try and work it through, see if there are any options available to them, such as extending of the furlough scheme or working from home. And in anything you do, try and act reasonably. So in conclusion, everyone must have an action plan. Planning is key here. So have a planning team. They can assess the working models, and then have your COVID-19 risk assessment. Have a walk around the building, see what works, see what does not work, pay particular emphasis into pinch points, and then keep your records and publish them. Show that you can demonstrate your compliance. Share and consult about measures and discuss individual concerns. Check your insurance to see if you are covered for any COVID-19 related deaths. Prepare for any spot checks, any health and safety inspections. Now's the time to perhaps a bit of forward thinking. Everything happened in a bit of a rush at the beginning, but have a contingency in place. Learn from what's happened, learn from any mistakes, and then prepare for in the event of a future pandemic or a second spike. And finally, keep up to date with government guidance. Thank you for listening.
Okay, thanks Amy and Vicky. That was really interesting and a great overview of the subjects covered. We've had a lot of questions in and we'll do our best to get through as many as we can. As I said at the start, if we don't address your question directly during this webinar, we will come back to you post the session. Either Vicky or Amy will do that for you. So let's start with some of the questions that were raised around the furlough section. I'm going to start with one that was actually posted pre-event, and it's one for Amy, obviously on the furlough side. Regarding redundancy and people on furlough, how would you manage consultation discussions when they are already working from home?
I think the answer to this just comes back to one of the last things Vicky said, which is about being the reasonable employer. So utilising whatever is at your disposal. It might be that if somebody is furloughed, that you have to utilise an online video platform. It might be, you know, Zoom if it can be secure, or Teams if you've got access. In some instances, I know that there are industries where access to those sorts of technology isn't very available. It may just be that telephone consultation has to happen, but just thinking about what your options are and how you can get it as close to best practice as possible. It can happen. It's just perhaps sometimes about being creative about how we get it done. Okay, great. Thank you very much. Just picking up on the points around director responsibilities, we've had a question in regarding that point. We furloughed a director, but he still comes into the office and uses it as a base for other businesses he's involved in. Can I clarify this is okay? Yeah, I mean, I think if he's not working for your business, the business from which he has been furloughed, then he's not performing services or generating revenue for you. So the furlough is legitimate. I suppose there are other questions there around use of your premises and his other businesses, but that's probably something else to consider. But I would suggest, so long as he's not satisfying that definition of work for you, then he's legitimately furloughed from your business. Okay, thank you very much. And one final question we've had in around furlough, or maybe this comes up into a bit more of a wider discussion, but when planning future employee requirements, can we legally enforce changes to staff contracts which take them down to part-time instead of full-time work as an option instead of redundancy? And how do we do this? Yeah, so a lot of people are asking about part-time working as an alternative. There is, of course, always a duty when you're thinking about redundancies to consider alternatives to redundancy, and that can involve potential changes to terms being proposed, or, you know, as well as things like voluntary redundancy, etc. I'd suggest it depends on the contract that somebody is on. Some people will have contracts which involve, for example, short-time working, which is always an option to consider on a temporary basis. But also how many people you're talking about, because the collective requirements will be different if you're over a certain number of employees. So it's quite a complex area, something definitely worth digging into and considering, and a worthwhile exercise, but yeah, dependent on a number of different factors. Okay, great, thank you. One more on furlough, and then we'll move on and pick up some of the questions around the coming back to work themes. Are you able to directly employ someone with a certain required skill set while some of your employees are still furloughed? Good question. Well, I would suggest that it depends who's furloughed and what skill sets they have. Because if you are missing a skill set in your business, full stop, irrespective of who's out of the business, then you're always going to be able to cover the need that is there. So I think it depends what skill sets are out of the business. You're not, when you're furloughing people, you're not necessarily suggesting that your business isn't functioning at all. You're just recognizing that there's disruption potentially in one area. So the business, you're going to want to try and keep functioning as best you can, keep generating income as best you can. Great, thanks very much. And I think, as Amy said, a lot of these circumstances are very individual to particular business needs. So if people do want to pick up additional points, then you can always give Amy or Vicky a call, of course, so don't hesitate to do that. Let's move on to some of the questions around returning to work then, and these ones will be for Vicky. Let's start with something on risk assessments. Are risk assessments only required for businesses of certain sizes? What if there's only one employee in the business? Okay, so the number of employees really will affect whether you really need to be having written records, if you've got 5 or over, to have that down, and also to publish would be if you've got the 50 or over. But what I would say is, regardless of how many employees you have, given the gravity of this situation, if you have one or more, then it is essential that you do undertake a risk assessment,
because in the event, or hopefully not, but in the event that something happened, you may need to be able to show what levels, what measures you've undertaken in order to try and prevent or use as a defence in any criminal or other liabilities that might be thrown upon the employer. So I think you should really, everybody should be undertaking a risk assessment as a result of this COVID-19.
Okay, great, thank you. I'm going to bundle the next two questions into one really, because they do cover the same sort of thing. There's been a number of questions around working policies and return to work policies, and really finding a framework available, or perhaps a best practice template. Let me just read out one of these points. So, can you say more about your suggestion to create a new safe working policy? Is there a best practice framework available? And just before you answer that one, Vicky, there was another question in here about my understanding is that the risk assessments for return to work only have to be written in a written format where there are 5 employees or more. Are we able to provide a template and a guidance for businesses to help them create policies?
Yep. So yes, spot on about the 5 or more written risk assessments. And as far as the content of the return to work policies, it's really more a case, again, just to be reassuring employees, workers, that they are returning to a safe workplace. Explaining or additional requirements for cleaning, or about distancing, or having mechanisms that who they can contact in the event of raising any concerns. And yeah, absolutely. If anybody does require any advice in respect to the content of these policies, then either Amy or myself will be more than happy to assist. Okay,
and I'm going to put one more out there before we sign off. You may not be able to answer this one. This may be for our commercial property colleagues, and if it is, we'll of course come back to you. And it's around shared buildings where there's more than one business within a building owned by a single landlord. Or there are perhaps 4 or 5 different employers in our building with few but some shared facilities. We do share front doors, staircases, toilets, etc., car parks. Our landlord has been spectacularly quiet and absent in any attempts to contact them about the COVID-19 risk assessment. What ought we do, as this places our staff at risk, but there's little that we can directly do without our landlord's agreement?
Well, I think for your own protection, again, undertake your own risk assessment regardless of the landlord, and then even perhaps talking to the other owners of the other offices and share with them what you deem to be a risk and what measures are being put in place, and ask them what they intend to do. And there will be shared access and entries and exit points, and other pinch points. So it is essential to share your findings and your results, and obviously try and find out if they're on the same page. And to obviously the landlord should be getting on board with this, but I think take control and discuss it with other people in the building to make sure they're all undertaking similar risk assessments, and then you're protecting everybody within the building.
Great, thanks very much, Vicky. They're all the questions answered. Thank you very much for everyone's contribution. Thank you very much to Vicky and Amy for providing a great insight into the subjects that we've covered. Is there anything you guys want to just touch on before we sign off?
No, just stay safe. Get in touch.
Okay, thanks everybody. We hope that was useful. We will follow up with the slides post-event and drop you some information. And like I said, if you do want to contact either Amy or Vicky, you have their details there, and we will send them across by email as well after the event. Thanks very much for joining, and have a nice day. Goodbye.
Thank you.
Thank you.